Well, as a corporate attorney, I'm sure you're involved frequently in preparing or critiquing partnership or shareholder agreements. What role does the fair value standard have in these legal contracts? And are legal practitioners bound by the confines of the standard?
Yeah, it's an interesting question. As a matter of good practice, as a lawyer, I would not prepare an agreement that simply says, in the event of a buy-sell, that fair value shall be the measure of value, because I think it just invites confusion. If you're going to actually get into the standard of value, I think you have to be much more specific. You have to dictate whether or not marketability discount will be used, a minority discount will be used. You actually may do better than that in terms of setting forth a formula for valuing the business interest. In litigation, if it is a shareholder oppression case, that is, a minority shareholder sues for judicial dissolution and then the majority shareholder elects to purchase under the fair value buyout statute, in that case, the court may very well look to the shareholders' agreement to see what the standard or measure of value should be, but ultimately it does boil down to applying fair value under the statute. So in other words, the shareholders' agreement can be influential, but not necessarily determinative.
Coming back to that question, if you have a shareholder dissolution, and we know that in the state of New York, for instance, the standard of value is fair value, but the shareholder agreement says that upon termination, the value of the shareholder's interest should be determined based upon, let's say, book value. Where do you go?
The results are hard to generalize. For instance, in many standard shareholder agreements, there'll be a right of first refusal provision, or actually that's probably a poor example, a buyout provision triggered by death or disability, which might use, for instance, book value. The litigation that you're talking about is where the minority shareholder has come in and said that he or she's been dealt with unfairly. They've been frozen out, squeezed out of the business. So the court isn't necessarily going to look at and use the measure of value that's set forth under different circumstances in the shareholders' agreement.
Could you identify for us or list some areas of concern that are the most prominent that practitioners should consider when utilizing the fair value standard?
Well, at the risk of repetition, there's still a lot of cases I see where the lawyer makes the mistake of not advising his or her expert that under New York, under the fair value standard, you cannot utilize the minority discount. Believe it or not, after 20 plus years of case law on this, that mistake continues to be made, and it's a horrible mistake for the appraiser to make. Sometimes you see that mistake manifested in how the expert applies a marketability discount, which really is a disguised minority discount. So you still see that happening. So that's a very important lesson that every lawyer has to know and pass on to their appraisal expert.
Do you think it's the appraiser's responsibility to determine this, or is it the lawyer's responsibility to inform the appraiser? What do you do when you work with the experts?
I'm a lawyer, not an appraiser, but when I'm looking to engage an appraiser, I expect them to know that. If they're practicing in the New York courts, I expect them to know that, for instance, in a minority shareholder dissolution buyout, that they're not going to be applying a minority discount. I'll tell them that anyway, but if they don't know that, I'm not going to be terribly impressed.
All right. Well, Peter, thank you very much for joining us today. You're obviously very informed and knowledgeable about the subject matter. Our guest today has been attorney Peter Mahler from the law firm of Farrell Fritz. If you have any questions on this matter, I'm sure Peter will be happy to assist you. You can reach Peter at his New York office. His phone number is 212-687-1230. As always, our audience is welcome to contact our offices with any questions or comments. Stay connected with us on the web at www.msgcpa.com, where you can also subscribe to our newsletter, Forensic Perspectives. We can also be found on LinkedIn, Facebook, Twitter, and of course by phone. Your topic suggestions for future broadcasts are always welcome. Until next time, this is Mark Gottlieb. Thank you for joining us.
You have just enjoyed another episode of Forensic Perspectives, hosted by financial expert Mark Gottlieb. For questions and/or comments regarding this broadcast, please feel free to contact Mark by phone at 516-829-4936 or via email at msgcpa@msgcpa.com. We also encourage you to visit our website, www.msgcpa.com. The opinions and commentary in the preceding program provided by our host and guests are for informational and educational purposes only and may not be their personal or professional opinion. No accounting, tax, or legal advice is being provided. The information provided within this broadcast is not an invitation for an attorney-client or accountant-client relationship. One should always seek the advice of competent professionals to assist in their specific needs. In addition, this podcast will not be updated for changes in accounting practices or law. As such, one should not rely on any information provided by this podcast. References to resources are provided solely for the listener's convenience. We have not reviewed or verified any information, advertising, products, resources, or other materials mentioned herein. This broadcast is copyright of Mark S. Gottlieb, CPA PC, all rights reserved. Any redistribution or reproduction of part or all of this broadcast is strictly prohibited unless authorized in writing.